All right, everyone, let us continue. Suit by third party stranger to contract. Now, the concept was already covered in detail in my previous session, so I'm not repeating the explanation. We'll just do a quick revision. Now, stranger to contract, let's say contract is between A and B. So A can file case against B, B can file case against A. Some third person or a stranger cannot sue either of the parties. See, stranger is a total third person who has no contract with either A or B. Even if the contract is for his benefit, he cannot file a case except under exceptional circumstances. Now, when two persons enter into an agreement, only they have the right to sue each other. Stranger to contract cannot sue. So the case law which they have mentioned is Dunlop Pneumatic Tires versus Selfridge. Let us go through the facts of this case. Dunlop was a manufacturer of tires. He asked various dealers, one of whom was Dew and Company. He asked various dealers not to sell the tires at below the recommended retail price. So he said that you will not sell tires at below the recommended retail price. Take a similar undertaking from various retailers. So Dew and Company entered into an agreement with various retailers, one of whom was Selfridge. He said that you will not sell the tires at below the recommended retail price, and if you do, you will have to pay £5 per tire to Dunlop. Okay. So Dunlop asked Dew and Company to enter into an agreement with various retailers. Dew and Company entered into an agreement with various retailers, one of whom was Selfridge. Now, Selfridge sold few tires at below the recommended retail price. Dunlop filed a case. Will Dunlop succeed? The contract is between which two parties? Now, there is a contract between Dunlop and Dew and Selfridge. Okay. So there is a contract between Dunlop and Dew and Selfridge. If Selfridge is not paying those damages, or if we want to file a case, so can Dunlop sue Selfridge? Dunlop cannot sue Selfridge. Dunlop is stranger to contract. Okay, he is a stranger to contract between Dew and Selfridge. If we want to file a case on Selfridge, Dew can file a case on Selfridge because he's the party to the contract. Dunlop cannot file a case because Dunlop is stranger to contract, stranger cannot sue. To give you one or two more examples, A gave 5,000 rupees to B and B gave that same amount to C. Now, B told C that you please repay this amount on time, otherwise, I will not be able to repay it to A. Now, B delayed in repaying the money. A filed a case against C. Can A sue C? Tell me. C is not repaying the money. Can A file a case against C? There is a contract between A and B, B and C. If C is not repaying the money, who can sue C? B can file a case against C. A cannot sue. Okay, he cannot sue C because A is stranger to contract, and stranger to contract cannot sue. Let's say, for example, A has to pay 25 lakhs to B. Now he doesn't have money. So he goes to C and he tells C, I will sell my house to you for 25 lakhs and then repay that money to B. So C agrees, he buys the house. He tells A that how will you carry 25 lakh rupees and pay the money to B? You do one thing, I will pay that money to B. C failed to pay that money. B filed a case against C? Can B sue C? There is a contract between A and B, A and C. If C is not paying the money, who can sue C? A. A can sue C. Can B file a case? B cannot sue C because B is stranger to contract, and stranger to contract cannot sue. Let me give you a variation. Okay, let me give you a variation. Now the money was with C. Yes, the money was with C. So C called up B. Are B, listen, I am holding the money for you. Whenever you reach home, just give me a call and I will pay the money. C gives acknowledgement. C gives acknowledgement to B. If C gives acknowledgement, law says that C, you are now considered as agent of B. Because you have given acknowledgement, I am holding the money for you. I am holding the money for you. So if you give acknowledgement, you are considered as agent of B. Now, if C fails to pay, can B sue C? Now he can sue because you can sue your agent. So yes, he can sue because we can sue our agent. Okay. So that was just a variation. There are certain exceptions. Under these exceptional cases, stranger can sue. I had already discussed difference between stranger to contract and stranger to consideration, so I'm not repeating the explanation. Let us directly jump to exceptions to stranger to contract. Now, under these exceptional cases, stranger can sue. Okay, stranger can sue. In case of a trust, now many students get confused. Ma'am, how will we understand that it is an exception? Contract is for his benefit. You normally say that even if the contract is for his benefit, he cannot file a case. How will we understand whether it is an exception? Try to find these words in your question: trust, family settlement, marriage contract, arrangements, assignment, estoppel, acknowledgement, covenant, contracts with agent. Try to find these words in your question. It is a hint that they are talking about stranger. Okay. Now, in case of a trust, X gave money to Y to be held by him in trust for Z. He says, Z is my grandson. I want him to get that money, let's say 15 lakh rupees, when he turns 21 years old. You hold it for him in trust. The person to whom that money is given is the trustee, and the person for whose benefit that money is given is the beneficiary. Now, Y is holding the money. What if something happens to X? Y is not giving that money to Z. Can Z file a case? Now, see, the contract creating the trust is between X and Y. Z technically is a stranger. But because the contract is for his benefit, he is the beneficiary. It is a trust. Beneficiary, even though he's a stranger to contract, can sue. The beneficiary, it means person for whose benefit the trust is created, even though he's a stranger to contract, he can file a case. Next, we have in case of certain family settlements. Now, let's see, for example, that Anil and Mukesh. Now, this is not a real example. Huh? Anil and Mukesh, they decided to partition their business. At the time of partition, they decided that each of them will contribute some money for the maintenance of their mother. Okay. So they entered into an agreement promising to contribute some money for the maintenance of the mother. After partition, both avoided to contribute. The contract creating that obligation was between Anil and Mukesh. Mother wants to file a case. Can she file a case? Here, mother was a beneficiary. It is a case of family settlement. If the terms are in writing, okay, if Anil and Mukesh they agree in writing to contribute some money for the maintenance of their mother, if they fail to contribute, mother, even though she's a stranger, she can file a case because the contract is for her benefit. Beneficiary can sue. When family disputes are settled by mutual agreement, one first requirement, settlement is happening by mutual agreement. Second requirement, the terms are in writing. Okay, everything must be in writing. So over here, they are agreeing, everything is in writing. Then such agreements can be enforced by members of the family who were originally not party to the settlement if the contract is for their benefit. So beneficiary can sue. In case of certain marriage contracts or arrangement, like say for example in case of HUF, some money is kept aside for marriage of a female. Some money is kept aside for the education of a minor. Some money is kept aside for the medical treatment of an elderly person. Even though they were not a party to the settlement of HUF. See, in case of HUF, when there is partition, male members basically get money for their family. Female members, as such, don't have any rights. But if money is kept aside for the marriage of a female, education of a minor, medical treatment, even though these parties, these persons, they are not party to the contract. Yes, I agree, they are stranger. But because this is for their benefit and it is in case of a marriage contract or arrangement, even though they are not parties to the settlement, they can still file a case. We are studying exceptions. Under all these exceptional cases, stranger can sue. Stranger can sue. At the time of partition, male members they agree to keep some money aside for the benefit, like for an elderly person or education of the minor or marriage of a female. The person for whose benefit the provision is made, that person may enforce the contract. That beneficiary can. So it's an exception. It's an exception. How will you find out? You will see marriage contract or arrangement. These words will be mentioned in that contract. Assignment of contract. Now, let's discuss an example to understand this concept. X paid premium. Okay, X paid premium and he obtained an insurance policy from the insurance company. Okay, he paid premium, he obtained an insurance policy. He went to the bank for loan. Bank said, I want security. X says, I have an insurance policy. Why don't you keep this insurance policy and on the basis of the surrender value, you can give me loan? So bank agreed to give loan against security of this insurance policy. Now, X assigned, okay, X assigned the benefit of this insurance policy to the bank. X assigned the benefits of the insurance policy to the bank. Now, what will happen in case bank fails to recover money from X? What if X is not repaying the money? Bank will go to the insurance company, surrender the policy and get money. Now the contract of insurance, the contract creating the insurance was between X and the insurance company. Bank is technically a stranger. Even though bank is stranger, because the benefit was assigned to him, bank can sue. Okay. So in this case, bank was the assignee. Bank can sue. Now, let us discuss this example again. I'm very sure you may want me to discuss it again. X paid premium and he obtained an insurance policy. He then assigned this insurance policy to the bank. Bank is the assignee. And he obtained loan. And he obtained loan. Okay. Now, in case X fails to pay the money, he fails to repay the loan, bank will surrender the insurance policy and he will obtain money. Bank is a stranger to contract between X and insurance company. So there is a contract between these two. Bank is a stranger, but because the benefit is assigned to him, he can sue. Bank is the beneficiary. In this case, beneficiary can sue. So over here, if the benefit is assigned, then the assignee can enforce the contract. Estoppel by acknowledgement of liability or part performance thereof. What is the meaning of estoppel? Estoppel, you must have studied in partnership. If not, let me discuss it with you. X, Y, they are partners. Okay, X and Y, they are partners. They have recently admitted M as a manager, very smart person. One day, X and M, they go for a meeting with supplier S. X introduces M. He is M, our partner. M is very happy. I am just a manager, but he introduced me as a partner. He's silent. He's very, very happy. Once the meeting started, M started explaining everything. S was super impressed. He said, "Wow, what personality. We must do business with such a person." So S agreed to give goods on credit, thinking that M is a partner. In case the firm fails to repay, can we file a case against X as well as M? Can we hold them liable as partners? Yes. When X introduced you as a partner, you remained silent. You did not correct him. You allowed S to believe that you are a partner. Now, even though you are not a partner, you will be considered as if you are a partner. You will be considered as partner by estoppel. So, estoppel means he's not actually a partner. He's considered just like a partner. Now, let's say, for example, that L has to pay money to M. Okay. But he gave that money to N. So he said, N, you are going to M's place, right? Why don't you give that money to him? I need to pay him 2000 rupees. N agreed. Okay. He agreed. He gave acknowledgement to M. Are listen, M. I am holding the money for you. L had to pay you money, na? He has given it to me. I am holding it for you. Whenever you come home, just inform me. I will bring the money. What if N fails to pay the money? Can M sue N? Can he? Now, in this case, the contract, okay, the contract is between L and M. N is a stranger. See, we had to pay money. We had to pay money to M, but we gave it to N, a stranger. However, because the stranger gave acknowledgement, he is considered as agent of M. Yes, I had mentioned it earlier, na, that the person to whom we give acknowledgement, he's our principal, we are our agent, we are his agent. So, N, even though he's a stranger, he is considered as our agent because he gave acknowledgement. Have we actually appointed him as agent? No. He is considered as agent of M by estoppel. He is not actually my agent. He is considered just like my agent. He is agent by estoppel. Now, even though he is a stranger, M can file a case because he is considered as M's agent and we can sue our agent. See, it is not one-way traffic that only stranger can sue. Case can be filed against the stranger, right? So here we can file case against the stranger. He is no longer technically a stranger. He's considered as our agent. But yes, he's not a party to the contract, but we can still file a case and recover money from him. Covenants running with land. What is the meaning of covenant? Now, covenants, they refer to conditions tied to the use of land or tied to the use of anything actually. Here we are discussing covenant tied to the use of land, but covenant basically means a condition. Okay. Covenant basically means conditions. Okay. Now we are discussing the conditions attached to land. These are conditions which specify how land should be utilized. X and Y, they are farmers. They own adjoining pieces of land. They have entered into a contract that this land will be used only for agriculture. We will not use this land for any other purpose. They have agreed. Now, the land will be used only for agriculture. This is nothing but a covenant. How a land should be utilized. This is nothing but a covenant. Now, the covenant is attached to the land. The land is burdened with those covenants. Whenever the land moves, the covenants will go along with it. Now, if X sells the land to Z, the Z, even though he has not entered into a contract accepting or creating those covenants, but he is still bound by the covenant because the land comes with a covenant. The land is burdened with covenant. These covenants are binding not only on the current but also future owners. Now, what if later on Y starts using the land for commercial purpose? Can X file case against Y? See, the contract creating those covenant, okay, the contract creating those covenant was between X and Y. Technically, if you see, Z is stranger. Yes. But because the covenant is binding on him as well, even though he's a stranger, he can sue. Stranger can sue. So covenants, they refer to the conditions tied to the use of land. They are binding upon the current as well as future owners. It runs with the land. It means that even though the new owner has not entered into a contract creating those covenants, but he is still bound to follow, he is still bound to abide by the covenant. So even though Z is a stranger, he can still file a case and stop Y from using the land for commercial purpose. Very important for any kind of exam that you're preparing for. Contracts by agent. Now, agent has entered into contract on behalf of the principal. The name actually in the contract is of principal and the third party. Okay. So, in this case, the contract is actually between the principal and the third party. Agent is just a connecting link. But because the agent has entered into a contract with the third party, if the third party fails to perform his promise, can the agent sue? Can the principal sue on behalf of the agent? Yes, because the contract is actually for the agent, for the principal. Agent is just a connecting link. So in this case, principal, even though he is not a party to the contract, because the contract is for him in his name, he's the person for whom agent is acting, then principal can file a case. He can enforce the contracts entered by the principal. So principal is a stranger, but he can sue. This stranger can sue. So these are the various exceptions wherein stranger to contract can sue. Okay, all right. Now the last part of this chapter, validity of agreements without consideration. Just write on the section number, section 25. Section number is very important for exam. We have already studied. No consideration, no contract. You cannot file a case if there's no consideration. But there are certain exceptions. Under these exceptional cases, contract is valid even if there's consideration for just one party. See, contracts valid without consideration. Without doesn't mean that there is no consideration for both the parties. Without means there is consideration for just one party. Even though there is consideration for just one party, it's a valid contract. The first one is extremely important for exam, very important for any kind of exam that you are preparing. Agreements made on account of natural love and affection. Husband promised to pay wife 25,000 rupees as pocket money out of natural love and affection. Now he's promising it's a contract, but there is consideration for just the wife. Husband is as such not getting anything in return. Some people say peace of mind is enough consideration. All right, no comments. Now, wife is getting consideration, but there is no consideration for the husband. Even though husband is not getting anything in return, it will still be a valid contract provided there are a few conditions which are satisfied. First, contract is in writing. It is based on natural love and affection. It is based means that particular contract is based on natural love and affection. It is registered. Okay, it is registered between persons standing in near relation. What is near relation? It means blood relation or marriage. So it is in writing. It is registered based on natural love and affection between persons standing in near relation. If these four conditions, all four conditions, they are all cumulative conditions. They are all cumulative. All four have to be satisfied together. If one is not satisfied, like it is not registered, no, then it is not falling under exception. These are all cumulative conditions. All have to be satisfied. So, what is the first condition? It should be in writing. It should be registered based on natural love and affection between persons standing in near relation. Then, even though there's consideration for just one party, still the contract is valid. Ajay and Vijay, they are two brothers. Ajay very rich, Vijay very poor. Ajay, out of natural love and affection, okay, Ajay, out of natural love and affection, promises to pay off all the debts of Vijay. Why Vijay is enjoying? His debts are being repaid. There is consideration for him. Ajay is not getting anything in return. But if the contract is in writing, registered, based on natural love and affection, between persons standing in near relation, there is blood relation, they are brothers. Contract is valid even though there is no consideration for Ajay. Last example, based on a case law, Raj Lakhi Devi versus Bhutnath. Husband and wife quarrel. Wife tells the husband, "You never give me enough money. I always have to ask from you. I don't like this." So husband tells, "Okay, I will pay you 5,000 rupees per month for your personal expense maintenance." Okay. So they quarrel and husband promises to pay. Now, there is consideration for the wife, 5,000 rupees, but there is no consideration for the husband. What if this agreement is in writing? It is registered also. But is it based on natural love and affection? See, there may be love and affection between them as husband and wife. But is this particular contract based on that natural love and affection? No, it's based on quarrels. So this condition is not satisfied. This is satisfied. They are in marriage relation. So only three conditions are satisfied. But this main condition is not satisfied. It is not a valid contract. It's not a valid promise. Okay. Agreement to compensate for past voluntary service. See, if X does something voluntarily, ideally, we cannot claim any remuneration. Okay, X has acted voluntarily, not at the desire of the promiser. We can't claim money from him. However, if the other party wants to pay, then we will never refuse money, na? So, promise to compensate either wholly or partly. A person who has already voluntarily done something for the promiser, that is valid even without considering. I'll give you examples. X found a purse belonging to Y. He returned the purse. Y then, out of gratitude, wants to pay 500 rupees as reward. Now, when Y promises to pay, there is consideration for X 500 rupees, but in this promise, in this contract, Y is not getting anything in return. But ma'am, she received the purse na earlier. Is it past consideration? No. Why no? because X has not acted at the request of Y. Do you remember in past consideration, I had mentioned that the other person acts at our request. Has X acted at the request of the promisor Y? No. He has acted voluntarily. It is not past consideration. So in this case, X has acted voluntarily. Y, if wishes, can pay consideration, can give consideration. So in this case, services have been rendered voluntarily by X. X on his own found the purse. Services have been rendered for the promisor in my example Y. Promisor was in existence at the time where services were rendered and he enjoyed the benefits. He intends to compensate the promisee. See, promisee cannot ask, give me 5,000 rupees, give me 500 rupees, I saved your life, I saved your purse. You can't ask. But if the other person wants, then they can make the payment. You can't ask for it, but they can promise to pay. Ma'am, will this be a valid promise? What if he promises and doesn't pay the money? You can file a case. It is enforceable. So, if the person has acted voluntarily for the promisor, services promisor was in existence, and he must have intended to compensate the promisee, then yes, definitely. Now, let's say that X, we take A. A saved B from drowning. Okay, A saved B from drowning. The act is over. He voluntarily saved. Now B wishes to pay him 5,000 rupees as reward. The act was done voluntarily. It was done voluntarily. B agreed to save him. Yes. Sorry. A acted voluntarily. B agreed to pay him. Now, in this, there is consideration for A, but there is no consideration for B. But still, it is a valid contract. Yes, it is still a valid contract. Now, A can't ask for money. He can't say, give me 5,000, otherwise I will drown you again. You can't ask. But the other person intends to compensate you. He wishes to reward you, then it is a valid. Here, A has acted voluntarily. If it was at the request of B, then it would be past consideration. Promise to pay a time barred debt. A had to pay 1 lakh rupees to B, but it is more than 10 years now. I will have to first explain what is a time barred debt. We have not studied this earlier. Yes, pay attention. A took loan in the year 2010. Okay. It has been 10 years, 2020. And B has not repaid. Sorry. A has not repaid the loan. So B gave 1 lakh rupees as loan to A in the year 2010. It is 2020 and B has not. Means it's more than 10 years now. Suddenly B realized that I had given some money to A. He goes to the court and he says, Judge, I want to file a case. I had given loan to A. He has not yet repaid. When was the loan given? 2010. Were you sleeping for all these years? What were you doing? If he has not repaid, you should have filed the case for debt. Okay, in case of debt, law has given us a time period of 3 years to file a case. After 3 years, this will become a time barred debt which is legally not recoverable. This is given in the law of limitation. Okay, this is given in the law of limitation. Like that, you have different time periods for different, tenancy is 12 years, debt is 3 years. So you have to refer the law of limitation. Now, A took loan in the year 2020, but he forgot to repay, and B also did not file a case. It's been more than 3 years. It becomes a time barred debt. Time barred debt is legally not recoverable. You can't file a case and recover. There are other means of hiring a gunda, don, but I'm not talking about that. So a time barred debt is a debt which is so old it remains unpaid or unclaimed for a period of 3 years. It is legally not recoverable. Okay? It is legally not recoverable. It is more than 3 years. Ma'am, why? See, we have given you a time limit to file a case because if you come with such an old case, we will have to keep aside murder cases, important cases, and try to, dig out records which are 10 years old. So we say you have 3 years time. After 3 years, you cannot file a case. So time barred debts, they are so old that they are beyond the point of time at which the creditor may sue the debtor. Now, let's say, for example, that A had to pay 1 lakh rupees to B, but the debt has become time barred. One fine day, A comes and tells B, now I have money. C was sitting over there. He said, Are A, don't pay, don't pay. See, you are promising to pay, but you are not getting anything in return. There's no consideration for you. Can't argue that Are A had received no in the past loan. That is a separate contract. Here he is promising to pay a time barred debt. He is paying. There is consideration for B, but there is no consideration for A, na? So will this be a valid promise? Law says, poor B. Anyways, this has become a time barred debt. He cannot legally recover it. Now, when A is on his own trying to pay B, you are stopping him. At least think from the point of B, na? He can't legally enforce the contract. If A is ready to pay, why are you stopping him? A, we'll put you in exemption. We'll put you in exception. If you promise in writing, you sign it or your agent signs it, and it relates to a time barred debt, then you can recover it. Okay. So if A promises in writing, it is signed by him and it relates to a time barred debt, the contract is valid even though there is no consideration for A. Contract of agency. No contract, no consideration is required to appoint an agent. Huh? So in order to appoint an agent, I don't have to enter into a contract with him. I need not give him any money. Acha, when will this be useful for us? Now let's say, for example, that X asked a truck driver to carry tomatoes for him. Now he was carrying those tomatoes and he met with an accident. He tried to contact X, but X was not reachable. He tried a lot, but X was not reachable. So the truck driver sold the tomatoes in the nearest market at the best available price. Okay, he sold it at the best available price. Is the sale valid? Now he's selling on behalf of X. Is the sale valid? If we are very rigid, nahi, how can the sale be valid? We have not appointed him as an agent. There's no contract only. Such sale will never happen and X will end up losing the value of tomatoes. They will get spoiled because you're not allowing the truck driver to act. But what if we put this into exception? See, listen. The truck driver is selling on behalf of X. It means he is acting as an agent of X. It's a necessity. It was an emergency. He tried to contact X and obtain instructions, but X was not reachable. So he acted on his own. So as an agent, can sell. Let us put this in an exception, na? No contract. In fact, no consideration is required to appoint an agent. So if we come up with this exception, see, no contract is required. No consideration need to be given to him to appoint an agent. So even though there is no contract, there's no consideration, he can still be considered as a validly appointed agent because we have removed those requirements. In such a situation, he can help us even though we have not appointed him as an agent. So law says put this as an exception. Even though there is no contract, no consideration, appointing him as an agent, he will still be considered as an agent by necessity. So no contract, no consideration is required to appoint an agent. Even without them, he can still act as our agent, and that exception will help us in such situation. There was no contract with the truck driver. We did not give him any consideration, but still he is considered as our agent. Sale is valid. So here the sale is valid. This truck driver is considered as agent of X by necessity. Completed gift. See, when you give gift to someone, you can't ask for return gift. See, we do, but we should not. Completed gift means gifts actually made by the donor and accepted by the donee. They are valid even without consideration. But completed, mere promise is not a valid contract. Gift must be complete. Mere promise is invalid because there's no consideration. X gifted 50,000 rupees to Y. Okay, he gave the gift, completed gift. He can't ask for return gift. So there is consideration for Y, but there's no consideration for X. Even then, it's a valid contract. But X promised to gift. Okay, it was just a promise to gift Y. Has he given anything to Y? No. Has he received anything from Y? No. There's no consideration. This is not valid. You don't even need natural love and affection. Nearness of relation is also not required. Near relation is also not. You can give gift to anyone. Same logic applies to charity also. X gave 5,000 rupees as donation to a flood victim. Now, can he ask the flood victim, what will you give me now? There should be consideration for both the parties. How can you expect consideration in charity? So, no consideration is required, even then it is valid charity. You can't expect anything in return. X promised to donate 5,000 rupees for the repairs of a church. He has just promised. See, it follows the same logic as gift. You have not given anything, you have not got anything in return. Mere promise is not a valid contract. But do you know something? The church authorities, relying on the promise, incurred 3,000 rupees as labor expense. They spent 3,000. See, I know this is just a promise, but X, you'll have to give at least 3,000. At least what they've spent. Ma'am, they spent 13,000. We will give only 5,000. What we promised. Okay, we will give only 5,000. Anything given in charity that is completed is valid. You cannot expect something in return for charity. Mere promise to give charity, that is not valid. You have not given anything, you have not got anything in return, no consideration, no contract. What if the promisee undertakes liability on the faith of that promised subscription? If he has undertaken liability, then you will have to give him at least to the extent of that liability. जितना खर्चा किया उतना तो देना पड़ेगा. There is something over here, ma'am. Bailment. What is this bailment? Now, let's say that X is the dealer. X is a dealer in stationery. He has a stationery shop, very small stationery shop. But this time he purchased a lot of notebooks to be sold in the month of June when schools and colleges reopen. He doesn't have so much space. So he went to his friend and he told his friend that, will you keep these notebooks in your godown? Most of them will be sold. Are bindas, you keep it. Don't worry, you're my best friend. You keep it. So X delivered the notebooks to Y's godown, warehouse. Okay, he delivered. This act of delivery is known as bailment. So, bailment means to deliver. The person who delivers the goods is the bailer. Person to whom the goods are delivered is the bailee. Has the bailee become owner of those goods? Bailee acts just like a caretaker. Bailer is the owner. What if something happens to the goods? Who will bear the loss? Of course, owner will bear the loss unless we find out that it was the fault of the bailee. No consideration is required to effect gratuitous bailment. Write down the meaning of gratuitous. Gratuitous means free of cost, free of charge. Free of cost, free of charge. Okay, this is gratuitous bailment. Now, let us discuss this. X asked Y, see, you are taking care of my goods. How much should I pay? Are you are my best friend? I will not take money from you. Leave it. It is just a matter of 2 months. Law says no consideration is required to create a valid contract of bailment, even though there is no consideration. It will still be a valid contract. Means Y is expected to take care of the goods. Y is expected to return the goods after the purpose is over. All the rights and duties of a bailee will apply to him, even though there is no consideration. It is valid bailment. You are bound just like a bailee. So, no consideration is required for gratuitous bailment. What is non gratuitous then? Non gratuitous means you are expecting something in return. X delivered the notebooks and Y is going to take care, and X is going to give him 2000 rupees per month. That is non gratuitous. There is consideration in non gratuitous. So, what is the meaning of non gratuitous? Here you expect something in return. Okay, here you are expecting something in return. Here there is consideration. Here there is consideration. But in non gratuitous, there is no consideration. Okay. So in gratuitous, there is no consideration. Even if there is no consideration, it's still valid bail. This is gratuitous. So in case of gratuitous bailment, there is what am I saying? In gratuitous, there is no consideration. In non-gratuitous, there is consideration. Mind is racing fast on how to conclude. Okay. So this is gratuitous bailment. It does not require any consideration. Still, it is a valid contract. All right. So students, with this, we come to an end of our discussion. In today's session, we discussed exceptions to consideration. I explained all the points with examples. Here also, we discussed multiple examples for each point. I also highlighted the keywords, a lot of marking. You can see there's a lot of marking. But that's how the basics of law should be understood. In my next session, as usual, I will discuss the writing practice with you. Please write and attempt these questions on your own. Don't leave it for the last minute. And then let us proceed to Unit 3.